Greetings to my class, Jumbo Africa. This is African Dignity. You are requested to like and subscribe this video so that we can make more videos like this. This is the last kicks of a dying horse to my class of 2025. Very good students that have done so well throughout the year, and I hope every employer, every law firm would want to work with students from the University of Zululand. So here is the provisions. This one is for the road. Guys, let us look at Act number 66 of 1965, which is the administration of late estates, right? This is now the administration of deceased estates. Okay, we all know that we are governed especially by Section 13 of this Act that says whenever there is a death, you have a duty to go and report the death at the master's office, and also we also go and report it at the Home Affairs, where you will get a death certificate. That right. Now, a client will come to you to say, I have just lost my husband, right? And your duty as the attorney will be to assist that client. Now, remember, the Government Gazette of 2014, if I'm not mistaken, 2014, yes, clarifies that if the value of the estate is more than 250,000, then you need an attorney to assist you with the rounding up of that estate. But if it is less, then you can go to the nearest magistrate or to the master's office and ask the master to issue you what is called a letter of authority, right? Letter of authority will be determined by the amount of the inventory, that is now what is contained in the estate. All right. So if the amount is more than 250, like I've said, so you will have to be assisted by the attorney to get what is called a letter of executorship, right? Remember, for a female will be called an executrix, and a male will be called an executor. So please don't forget to make those differentiations: executrix and executor. Okay. Now, but I want to draw your attention to the mistake that is committed by most lawyers, a lot of them, including myself, that when you get to the master's office, they will issue you with a standard form. It's a standard form that is there in the master's office. And once they give you that form, it is the letter of executorship form, all right? But the mistake that they have, they always write that it is issued in terms of Section 13 and 14 of Act 66 of 1965, right? So be careful, because there is a catch. There is a big mistake that the master is making when they issue those letters. One day you will get to court and you will be found wanting if you don't scrutinize the provisions of these sections. They are very important. All right. There is also a case in point that I want to draw your attention to. And this case is called Setati versus the Master of the High Court. And you must know that this case is unreported, but it is a groundbreaking case where this mistake was made and the respondents were found wanting because they had been given a letter of executorship with this mistake that I've just mentioned, that it's issued in terms of Section 13 and 14 of the Act. Okay. I will just read you the case number. It is Sitati that is now C30, if you like, C30 versus Master of the High Court and another. The case number is 3343/2019, right? And the judgment was given on the 19th of May 2020. Hey, today, it was given today. Very good. It's a coincidence. Today is the 19th and I'm reading this case. So judgment was given on this day in 2020, 19 May 2020. So you can have a look at that. You can have a look at that case. It will definitely assist you. It was in the High Court of Limpopo. But what I want to draw your attention to is two sections. When you go and read that case, don't read everything. Just go and read section 10 and also read section 12 of the Act. Okay. So what we'll find out on the section 10, it will say, it reads as follows. The letter ex face, the document, were purportedly issued in terms of section 13 and 14 of the Act, which is Act 66 of 1965. And the relevant part of section 14 provides as follows. So please listen carefully now. It provides as follows. The master shall, subject to subsection 2 and section 16 and 22, on the application of any person who has been nominated, that's very important, person who has been nominated as an executor by any deceased person by way of a will which has been registered. Very important. Person has been appointed by way of a will to be an executor, but that's not enough. That will must be registered and also it must be accepted by the master. What do we mean by that? That means the will must comply with all the formalities of the will. Remember that the will must be signed in front of two witnesses, so it must comply, and all the pages must be initialed by everybody who appended a signature on that will. So all those, then it must be seen that it was never done in duress and all of that. So the master will do that inquiry because they don't want that the will should be challenged. So it is important that having a will, so say, I have a will and that will is not registered, it is good. It's as good as if there is no will yet. So the will must be registered and also be accepted by the master. Okay, fair enough. Now, what happens is section 14, we've read it now. Section 14 says there must be a will. So now the mistake that the master does, and it's going to be that mistake for a very long time until one of you guys go there or write a research paper regarding this to say, master, please change your forms, because that form is going to make people suffer or be deprived of their inheritance. Because now if you go to the master's office and say, because they will ask for information from you and you let them issue a letter of executorship on a wrong section, it will be like you have defrauded, you have told a lie to say you have a will, because that letter of executorship is issued in a section where it's supposed to be, there's supposed to be a will in place. And if there's no will, that means you have lied. And I know it's not your fault, but your opponents will say you misrepresented the facts and you said there was a will. That is why you were given an executor under that section, because that section is very clear in the Act that says if there is a will. So what is the opposite? What is the correct section that the will should be issued on? It is section 18, right? Subsection, I think subsection 18, right? Of the, yes, subsection 18. It says the master will, subject to the provisions of subsection 3, subsection 5, and 6, right? If any person has died without having a will, right, which he has nominated any person to be the executor, then the master will appoint and grant letters of executorship to such person. That is now. There is no section 8, there is no 18, there is no will. Section 14, there must be a will. So you cannot issue letters of executorship under section 14 if there's no will. You have to issue it under section 18, because I've said that is a standardized form from the master's office. What do you do as an attorney? You bring it to the attention of the master, because you must know these people who are called masters are just ordinary law students like yourself who are not even admitted attorneys. They just pass LLB like yourself, and they are scared of going to court. They choose to do what? To go and apply at SARS, at RAF. Some go to the master's office to look for. I hope we are clear with the relevant section that should be used when you are being issuing a letter of executorship. So we are very clear. It's 14 and 18, very important. And also there's a section 54. Section 54 is about when you want an executor to be removed by the master. So you will use that section. So you will make an application in terms of that section, which is section 54, if you are removing an executor who is maybe extravagant, or who is fraudulent, or who has failed to administer the estate, diligently, or who's taking his time to do that, to administer the estate. So you can use section 54 of the same act, right? Now let's come to something called the J84. A J84 is a form that you will also be given by the master. And that form will have small blocks that you need to tick, because it will ask a question whether this person is a divorcee, is married, is widowed, and all of that. And there is a problem currently. That is why I am very passionate with the registration of customary marriages. Listen, now, this is what normally happens in many families. What we call abakongi, those people who come to negotiate marriage, will come to your house, right, and come and negotiate a marriage on behalf of their son or nephew, if you like. Now, with the new act, the recognition of customary marriages, the moment negotiations start, whether they are successful or not, once they start, the law says there is a marriage. So a person can come to your house and say, our son saw a lady at your house and he feels like she will be a right suitor to be a bride. And then people will say, okay, how much lobola are you going to pay? And then they'll say, yeah, but our son is still studying. Maybe we think he might probably work somewhere around 2035, so 10 years from today. This is 2025. So we think maybe by 2035 he may work. And then we agree on that. And then they give you a list of easy so to say what gifts are you going to give for the bride's family. And you go with that list and you vanish and you never come back. Right? You never come back. 2035 comes, you don't come back. But your son and their daughter are together. And they've already got a kid or two. And if the son dies, or anybody dies, whether the bride dies or the son dies, when you go to the master's office will say the marriage exists, but on a certain condition. It just doesn't, you don't say, no, they've paid lobola, so automatically now I am a spouse and I must claim 50% if there was no will, 50% of the husband. It does not work like that, because the death certificate of the husband will come and say never married, because negotiations were made and you forgot to go and register the marriage at the Home Affairs. So what do you do? In that form, the J84, there will be a space where you must mark whether there was something called a marital declaration. How do you do marital declaration? This is how we do it. Some people at the master's office may not know this, but the senior guys at the master office, the senior officials, the managers will know this. You go and talk to them and say, we want to make an appointment for a marital declaration. How do you do it? You bring two people from the bride's homestead and two people from the groom's homestead. They go to the master's office with a induna or a chief, right? And or as an affidavit written by the chief that will say, yes, there was a marriage going on such and such a year between these two people. That will be good enough, even if Induna hasn't come. But it's good that they also go and be witnesses, because there you'll be filling an affidavit where you will all sign to say there was negotiations, so therefore there is marriage between the two parties, right? Then the wife of the deceased or the husband of the deceased will then be recognized as having been married to the deceased. So it's done like that. But the mistake that people do, you just go to the master and say, yeah, somebody paid lobola for me, and the master will say, okay, if you say so, then you are the spouse, you must inherit. It does not work like that. You've got to do this exercise. If you haven't done this exercise, you are still not the lawful spouse of the deceased. So be very careful. When you get to practice, please do this. Remember me. If you forget, you must give me a call. You all have my number. Jambo Africa.